Can a habitability issue that develops while an eviction is pending in court prevent a landlord from evicting a tenant in California? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I had this exact issue come up on one of my cases. The scenario was this: landlord's tenant didn't pay rent sometime like in January of this year. It took a couple of months for the case to go through court, and we were in court a couple of weeks ago, and like 2 weeks before the trial date, there was a plumbing issue at the property that caused flooding inside the rental unit, basically. And it happened literally like 2 weeks before trial. Landlord sends out their plumbers and so forth to stop the flooding, get the leak under control, and then there was remediation that needed to be done. So obviously the tenant was gonna raise this in court. We prepared for that, and the question became, you might have this question too: does a habitability issue that develops after a 3-day notice is served to a tenant and after a case is filed, does that impact landlord being able to evict a tenant for not payment of rent? The answer is it shouldn't. Okay, that it shouldn't, but it could possibly affect the judge awarding daily rental damage for the dates that the habitability issue existed. Okay, so here's the deal. Under the Civil Code and under the Code of Civil Procedure, there are certain rules and procedures that a landlord has to follow. One of those everyone kind of knows about is the warranty of habitability. The landlord has to, have certain features in the rental unit to make sure that the rental unit is safe for human habitation. Okay, one of those items is you got to have like plumbing that works properly. Okay, having a leak that causes a flood in a unit is the definition of a breach of the warranty of habitability. Okay, now Civil Code Section 1942.4 goes on point and states that, hey, if you have issue with your rental unit, like you lack any one of the features in the Civil Code or the Health and Safety Code that defines what a safe and habitable unit is, or if there's a condition that affects health or safety, you can't issue a 3-day notice for rent. You can't demand rent. You can't collect rent legally while those conditions exist. You have to fix them. Okay, well, in this scenario, in a scenario where you might have served a notice several months ago where there was no issue, you haven't violated the Civil Code. Okay, so the underlying 3-day notice should be valid, and sometimes, occasionally, issues come up. Now, the landlord still has the duty to make sure that these items are safe and habitable throughout a case. And I always will tell my landlords, if something does happen during the unlawful detainer process, work with your tenants to see if we can get that fixed. If not, you could possibly use a 24-hour notice to enter. Obviously, when the case is in court, you're going to want to consult with your local legal counsel how to handle those items. Okay, because every scenario is going to be different. Most people in general, when something breaks, they're going to allow you to fix it. But sometimes there might be difficulties, okay? And at that point, you're going to want to document those difficulties. Here's the outlying issue, and this is the issue I ran across. Possibly that could open the door up for a judge to adjust what's owed, okay? And it's in Code of Civil Procedure, Section 1174.2. Now, if a court does find that, if the tenant raises an affirmative defense of the breach of the warranty of habitability, or there is an issue, the court could is really required to adjust the daily rental rent that's due if there's a material breach. Okay, and usually that's done on a conditional judgment. It basically says, hey, listen, the tenant owes money, but there was some issue. Okay, now in a normal habitability circumstance, if you issued the notice, right, 3-day notice, and there was a habitability issue at that time, the judge could order a conditional judgment, meaning, hey, we're going to adjust the value of the rent that's due with this habitability defects. I think it's worth X amount of dollars. Okay, the rent's $2,000. I'm going to adjust it to $1,000. I'm just keeping it, simple. Okay, tenant, you're ordered to pay $1,000 within 5 days. That's kind of what's written in the Code of Civil Procedure. If you do that, tenant, you get to stay in possession, and landlord loses. Okay, but if you don't pay the landlord, the landlord wins and can still evict you. That's how it normally works. But when you have an issue that happens afterwards, that doesn't really impact the case. But I do think there is wiggle room in the Code of Civil Procedure that the court could adjust the daily rental damages for the time that the issue was impacted. The habitability issue impacted use of the rental unit, so to speak. So, and that's kind of what happened in the case that I had here. But I was concerned that the judge could, sometimes, orders an issue when there's no legal basis, that type of deal. I wanted to make sure we were on the same page with that. But reading some of the cases and so forth, I don't think there hasn't been a case that's actually become an issue that has gone up on appeal. Any one of my practitioners that listen to these, you got something, send it over to me. I just couldn't find it. So that was my war story there. The thing is, with habitability issues, you want to treat them on a case-by-case basis and promptly get them fixed. So this one ran a little bit longer than usual. It's a war story, but I'm going to say, landlords, if you're in the Northern California area and you got non-payment of rent or habitability issues, and you kind of need help sorting that stuff out, what you need to do, that type of deal, or you just got, you're dealing with a non-payment of rent situation, feel free to reach out. We might be able to help out. Put your comments, questions down below. Try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. See ya.